Now, this is a landmark case, R versus Govinda, where a distinction has been created between the two offenses. Very nice distinction, because 1860, IPC was enacted, came into force, and this case is 1876, the first case to, create a differentiation between or clarify a very clear, the interpretation of the two sections. And that interpretation still holds good in different cases, subsequent cases. The same interpretation continues. Maybe something new is being added every time. Right? So let's see. If you see, a person commits culpable homicide if the act, so we are talking about the act. Act of what? Act of the result, causing the resultant, that is death. And death also not lawful, unlawful death. So the act causing the unlawful or the culpable homicide by which the death is caused. So this act is causing the death under different conditions. Let's see first culpable homicide. With the intention of causing death. Intention, I said, strongest form of mens rea, guilty mind, clear-cut desire to have that man being finished, killed. So, yes, this comes under this, clause 1. Clause 2, with the intention. So here also, intention is there. Desire, act तो है ही ऊपर, which has caused the death. Act plus what? Desire to cause a bodily injury. Now here it was clear-cut causing death. Intention is very clear. Desire is very clear. Here the desire has come down to what? The act is causing the bodily injury, and that bodily injury is intentional. Getting it? Intention to cause such bodily injury which is likely to cause death. So intention is there, but intention is not clear-cut causing the death. That is covered under the first clause. In the second clause, intention is caused to cause a bodily injury. And what kind of bodily injury? Which is likely to cause death. There is a possibility, strong possibility maybe, likely is related to that, of causing death. Okay? Now, third, let's see, then we'll come back to murder. With the knowledge, now intention goes and comes the second level of mens rea, the lower level of mens rea, knowledge. Knowledge of what? That the act he is doing is likely to cause death. By doing that act, he has the knowledge, that means he has the consciousness. In his mind, he has a clarity about this, that what act I am doing is likely to cause death. You can see the difference between the two. Third, first वाला तो बिल्कुल clear है. Second and third. Second is intention to cause such bodily injury which is likely to cause death. But with intention, a desire. Here there is a knowledge that what act he is doing is likely, may result in death. In his consciousness, he is clear about that. His act may cause death. Is likely. May से भी ऊपर आ जाएगा. Now let's go back to section 300 now. Murder. First is very clear. So in case there is intention to cause death, it will be covered under the higher category, that is murder, unless there are other circumstances which will be explained later, little later, where murder, even if it is caused intentionally, the death will be covered under the culpable homicide category and will be to. Otherwise, all intentional killings are murder. Right? Now, second clause, we will be, in our mind also we'll be comparing the two with the intention. That means there is a desire, strong desire of causing such bodily injury. Now, if you see here up to this and this, here also there is intention of causing such bodily injury. Stop here. Stop here. Up to this, no difference. The difference starts now. How? As the offender knows, the person who is committing that act, इंटेंशन तो है ही है बॉडली इंजरी करने की, उसके ऊपर एक और है नॉलेज ऑल्सो. नॉलेज अबाउट व्हाट? नॉलेज अबाउट दिस बॉडली इंजरी. यहां पे नहीं है, यहां पे लाइकली है, बट हेयर इंटेंशन प्लस नॉलेज ऑफ बॉडली इंजरी लाइकली टू कॉज दैट. जो लाइकलीनेस है यहां पे, इस पे उसकी नॉलेज नहीं है कि इट्स जनरल, बट देयर ही ऑल्सो नोज दिस कि जो बॉडली इंजरी मैं कर रहा हूं, इन्फ्लिक्ट कर रहा हूं, दैट इज लाइकली टू कॉज दैट. सो इंटेंशन टू कॉज ए बॉडली इंजरी कपल्ड विद नॉलेज, स्ट्रॉन्ग बन गया. Right? Next, with the intention of causing bodily injury. यहां तक फिर सेम, ये भी सेम, ये भी सेम. बॉडली इंजरी की बात हो रही है यहां. Intention of causing bodily injury to any person and bodily injury intended to be inflicted. This is sufficient in the ordinary course of nature of causing death. Here knowledge की बात नहीं कर रहे. इसमें और इसमें फर्क ये है, इसमें नॉलेज है उसकी कि this injury is likely to cause death, which he is intending to inflict. Here it is same. There is a desire, intention to inflict a bodily injury, but that bodily injury is of such nature, such dangerous, which is sufficient in the ordinary course to cause death. Can you see the difference of intensity? Intensity किस बात की? The resultant. Resultant is the death. दोनों में फर्क थोड़ा थोड़ा क्लियर हो रहा है. अब आते फोर्थ क्लॉज पे. If the person committing the act, right, knows, here we are talking of not intention but knowledge. Knowledge of what? Is doing an act, but he also has the knowledge that the act is so eminently dangerous that it must, see, to ensure, it is ensuring that the act, it is not talking about bodily injury or any other thing. The act itself is so eminently dangerous that it must, in all probability, highest level, har halat mein, is likely to cause death. Likely, again, word has been used to attach possibility, but probability is the highest. Can you see the effect? Likely word causes, links us with the possibility. But when we say no, sufficient in the ordinary course of nature to cause death in thirdly may, or here, in all probability, must, in all probability, surety hai death hogi hi. So that means what? The mental condition as well as the coupled with the act which has resulted in the death, coupled with that, the court will see in which category it fits into that, and accordingly the charge will be proved or laid against that person. किस कैटेगरी में आएगा? उसका मेंटल कंडीशन, intention, knowledge, or and coupled with the act. If the act is imminently dangerous, it must in all probability is likely to cause death. ऊपर चले जाओ, knows that it is likely to cause, intention is there that it is likely to cause death in this ordinary course of, it is sufficient. The bodily injury is sufficient to result in the death. So, if we look at any condition, any facts of the case, as a judge, as a person examining the facts, as a law student, as a legal professional, what we must look into? The knowledge part, the intention part, that is what is happening in his mind, and the kind of the act which he is performing, what is the likelihood of the death through that act? Is it only likely or in all probability, in sufficient course? So that will create the difference. Or if the act itself is so imminently dangerous.